Hello, welcome back to our 2017 Educational Webinar Series. I'm Dr. Jill Brooks, Senior Director of Education for First Healthcare Compliance. At First Healthcare Compliance, we help you with a comprehensive compliance management solution tailored to your business, a hospital network, healthcare practice of any size, billing company, or skilled nursing facility. As part of our complimentary educational webinar series, we bring you experts from around the country to discuss relevant topics in the healthcare industry. We continue our March webinars focusing on the topic of contracts and services. We're so pleased to have Mark Cunningham of Chambliss, Bahner, and Stophel presenting Dealing with Difficult EHR Vendor Issues. Mark chairs the firm's healthcare section and serves as counsel for leading healthcare participants on a regional and national level, including medical practice management companies, billing companies, physician practices, outpatient diagnostic centers, ambulatory surgical centers, hospital-based providers, dentists, optometrists, home health agencies, assisted care living facilities, and hospices. Mark has worked with clients to navigate a wide variety of healthcare laws and regulations. As an example of Mark's experience, he has recently worked with clients to address the following areas of concern: practice acquisitions, physician practice restructuring, physician employment agreements, professional service agreements, physician hospital ventures, medical director agreements, EMR agreements, Stark and anti-kickback compliance, healthcare and payer audits, co-management agreements, non-compete and non-solicitation agreements, HIPAA and patient privacy laws, physician recruitment agreements, Medicare enrollment, payer disputes, and antitrust law. A copy of the handout is available for download on the control panel. Feel free to submit questions during the presentation. We will address them at the end. Your Paycom CEU certificate will be emailed to you from Paycom following the broadcast. There's no need to request it. This should come to you within about 48 hours. Additional CEU opportunities will be available to BC Advantage members following the live broadcast. Please check their website for details. Go ahead, Mark.
Thank you, Jill. That's, I'm going to have to shorten that bio in the future. I always curious on when presenting on webinars because I tend to like to have the human interaction. So I'll do my best to keep you somewhat awake on your end, but I have no guarantee that I'll be able to verify that when we're done. So I guess we'll be on the honor system. A little background before we get into this webinar and give you some perspective on where I'm approaching the issue is really from a perspective as an attorney for a variety of different types of players within the healthcare industry. We've worked from the perspective of the vendor, worked as an attorney from the vendor perspective, from the billing company perspective, from provider perspectives of all different shapes and sizes. And what you just realize is that when dealing with EHR, there is such a push to implement the digitization of patient information. Yet as we rush into that, we don't always have the answers for the problems that come up, whether that's at the outset of the relationship, during the relationship, or at the end of the relationship. So my goal in this presentation, or my hope on this presentation, is to walk through the issues with you that I'm seeing on a day-to-day basis, but I'll be doing it from the perspective of an attorney and really almost using the contracts and the contracting background that exists to provide us some, I guess, a pathway through the discussion. So let's go ahead and move into it. As I had said earlier, I like to look at this as the new digital world that we're working in. You've had such a push from the federal government and from providers across the board to try to streamline electronic health information towards the goal of having ultimately a single record which allows providers and practitioners to communicate effectively with each other and with their patients. I think that most of the folks within the industry know that that is still a utopia. It is a dream. It has not yet been realized. You see competing systems that don't communicate like we would hope that they would. We see issues with breaches of health information. We see a number of different problems that arise. Fundamentally, though, it is the world that we are moving into. And as a part of that process, healthcare entities must choose the right EHR platform. And I'm going to refer to it as EHR throughout, although there are different acronyms that you can see, whether it's electronic medical records, the EMR. There are different terms we can use, but for sake of consistency, I'll refer to it as EHR in this presentation. But as you'll see in there, and what I've written down, is that you really do have to choose the right EHR platform from the outset. And that's a complicated decision. One, because there's so many different choices that exist out there. There's so many different vendors. And I really believe that interoperability of the systems creates some significant issues. Regardless of where you are, a lot of folks have made this transition previously into the digital world, and now they're moving to a new system, and you're learning that moving data from one electronic health record platform to another is fraught with its own risks and issues. You have the other common issues that come up with any type of digital or electronic system, and that's server outages, data loss, data entry. I know that we were talking and joking even before the presentation of this webinar of what happens if we have a power outage and how to adjust to that. That's just become the ordinary day in, day out for the IT networks and personnel that are working on EHR systems. It is often a world fraught with immediate issues and problems that have to be responded to in the short term, and then we're going to deal with some of the long-term issues as well. So hopefully we'll get into this and look at how do you manage and negotiate those relationships at the outset and do it in a thoughtful and deliberate manner. What you'll know if you've been through this process or if you're anticipating going through this process is it isn't easy. The choice of an EHR platform can overwhelm you. And what I would like to focus on and really draw your attention to is how do you know what you're getting, what you need? Fundamentally, I think that the providers have to question the vendor at the outset of the relationship. And that requires an assessment of your own current technology. Is this new software going to interface with what you have? Will there be a transfer of not only your patient information, but operability with other systems that you maintain? Furthermore, I think that you have to look at your external resources and external partners that you deal with on a day-to-day basis and understand whether or not the new EHR platform is going to integrate seamlessly, which is, I can probably assure you won't happen, but at least integrate in a reasonable manner with systems of other providers. If you're a smaller physician practice, knowing what your local hospital is using and ensuring that things can communicate effectively is critical. You need to know what additional software you may be required to purchase to operate the system. You need to also understand the scope of the EHR system you're acquiring. I think one of the bigger problems you can run into is buying something that's too big for you. And especially on the smaller practices, you get into situations where you've bit off more than you can chew, and it's a frustrating dynamic. And finally, I think you want to explore with your vendor to what extent they offer customization, how you're going to deal with issues that may arise in the future. So first step I would say is in the selection process is you need to get your team ready and understand who is on your team, who is going to represent you in the negotiations. If you're in a smaller practice, you may be delegating this selection process to one key physician, one key owner, maybe a practice administrator. However, if you're a hospital system, you're suddenly dealing with the brand new world of bureaucracy because, in my view, hospital integrations end up involving a wide variety of people, and the communication process is challenging in and of itself. There are different areas of control that people are having to give up or to fight for, and that can be awfully challenging. I think the other thing I would note to work out and be on the lookout for is the fact that the vendors and key people who are involved in the recommendations have a vested interest in a particular vendor. I think understanding the financial relationships between the vendors and the people who are making the selections is important. Hopefully there aren't any conflicts, but it's very important to identify that on the front end. I think that regardless of the concerns on the vendor influence on the choice, it's critical to establish a relationship of trust with your IT vendor. You have to understand that, one, they know what they're doing and their product is good, but also coming together and realizing this is going to be one of the critical partners for your healthcare operation, whatever size it is an item that can't be overlooked or undervalued. Regardless of your size, this becomes an absolutely critical member of your team moving forward. And of course, I'd say just from a personal standpoint, I always am curious as when do you get your attorney involved on the healthcare side of things. I don't think it is, there's an easy answer to that, but oftentimes attorneys aren't involved at all in the process until something goes wrong, and that's usually too late. That's one where you end up paying probably more than you should to deal with the problem when you could have addressed it on the front end. Fundamentally, it's truly a fact-specific situation, and you have to get to a team of decision makers with the skill sets and knowledge that you can trust whenever you move into acquiring or changing EHR systems. The 5 key relationship issues I would touch on once you get to the point of you're ready to move into a new vendor relationship. Identify fees. We'll talk about both real and hidden fees as we get into this presentation. I think service level standards become critical. The concept of representations and warranties, also critical. Disclaimers, limitations of liability are a hotly discussed negotiation point, and rightfully so. And finally, I'd say transition of data upon termination. I might even include and expand that, a transition of data upon termination, or really at the outset of the agreement if you are transitioning systems. So let's talk about the first issue, and that's fees. And I would say the first step is to actually identify the fees that you actually need. When you look at some of these EHR contracts, they are maddening, even for those of us who have been through the process a multitude of times. You end up with, you'll see a list of the types of fees that you can run into, and sometimes they overlap, sometimes you're not sure what they are, sometimes even the vendor isn't quite clear at the outset as to what the fees are. Licensing, software, consulting, equipment, you can go on and on. I'm sure I'm missing about 30 other fees that can be included in these contracts. Sometimes with unsophisticated clients, they don't challenge or fully understand the fee structure. Even with sophisticated clients who are purchasing systems, I would focus on that latter part of fully understanding the fee structure. That can be lost as well. And from my standpoint as a lawyer, when working on these arrangements, it's critical to understand each fee, understand whether it is tied to a service, is it tied to an item. There are different legal and practical considerations as you move through the process, and you have to know what you're paying for. I would tell you, though, that there are too many contracts where people get into them on both sides without a full understanding of how the structure works, even on the most basic of terms. The second thing I would say is let's have a real talk whenever you're looking at the EHR system. You need to know what you're buying. This goes to the point earlier that I had alluded to, that there are a number of providers who will buy systems or buy platforms that are over expensive, that are too much for their particular system. Make sure that you're getting what you need and not paying for systems that you don't need. I think that what I'll find is oftentimes people can start relatively limited or conservative basis and add on down the road to the extent that they need to add things. Obviously, from a vendor perspective, they may be pushing for more at the outset, but you need to know what you need, and testing that system out and going through some test runs is going to be critical to understanding that process. Talk a little bit about specifics on fees and negotiation, I'll say tactics, but these are things just to be aware of and what we'll see in contracts. I think fee increase provisions can sometimes surprise clients whenever they're in an EHR relationship. Do your best, if you can, to set caps on fee increases. Sometimes we see clients who use the Consumer Price Index, that's referred to as CPI in the handout or on your screen, and that's used as a ceiling to ensure that adjustments aren't suddenly coming upon you at significant amounts. Don't want to be hit with a 20% cost increase in an unexpected manner. And sometimes I've seen vendors who draft very favorable provisions. I've drafted them as well whenever I'm representing the vendor to give them the flexibility to deal with increases down the road. But within the contract, that's something you need to focus on. I would also say focus on limiting the frequency of fee increases. How often can those fees increase to the extent you allow them to increase at all? Other items where you need to be particularly attuned to fee increase events will be upgrades, add-ons, to the extent that you have a blended contract where equipment and or services are involved. How will changes to that equipment or staffing affect your fees? How will termination affect your fees? These are all key issues to look at and to be aware of within your vendor contracts. And I would say as well, to the extent that you're in a bad contract or you're in a contract that leaves you vulnerable, look at the next amendment opportunity. The next amendment to your contract is an opportunity to address some of those shortfalls, maybe close some of the gaps that exist. Last part on fees that I really want to touch on are what I'll say hidden fees. These are not the fees that are necessarily set forth in the outset of the contract, but these are the ones that come upon you when you least expect them. Hardware, training, setup, travel, oftentimes those aren't discussed in the initial contract. You also get caught in situations where the providers, basically the purchasers of the EHR, end up having to stage the system on their own. They have to build the system internally, and you end up having a lot of downtime with your staff where they are not just training on the new system, but effectively having to change it or build it internally to fit their practice model. That's extremely burdensome, both from a morale standpoint, but also extremely costly. What I would say is anticipate that and do your best to truly understand what it's going to take to turn this system into one that works for you. That's a lot of work with the vendor, and it's a lot of work with that team that we talked about earlier of ensuring you're going to implement things appropriately. Other hidden fees could be downtime, workflow interruptions that are tied into the installation and or transition process. Do your best to negotiate that on the front end. Negotiate a fee with the vendor or a fee decrease for anything that disrupts your workflow or revenue if these standards are exceeded. If you're converting a legacy system, a system that you're moving and transitioning from one system to the other, I think you need to address who's going to be responsible for the quality assurance, the QA there on your screen of the new data, and to ensure accuracy of the data. I think that providers find out that's going to be their cost if it's not addressed, and this can sometimes be very dramatic, and the leverage that is there is lost if you haven't addressed it on the front end. I think that you want to ensure that test files and the conversion process is built in as a part of the contract. Set terms, set standards that address how things are going to be provided and how you are going to ensure that the conversion from one system to the other has been accurately and fully completed. If you don't address these things, you get into the area of hidden fees. Ambiguity leads to these costs, these expenses, potentially to litigation. You can't be relying on something that Timmy said to Sarah in the back room and expect that that's going to be okay. Fundamentally, most of these agreements are going to disclaim any comments, conversations, things that were said and are not actually set forth within the contract. While legally that sometimes can have some weight, be expecting the contract you sign to clearly and definitively exclude that as evidence when you're trying to determine who's responsible for what. So a little bit of discussion on fees. Let's move into sort of the next phase of the contract and issues where you need to be aware of when entering into a new EHR contract. I think that service level standards are a basic component of any EHR contract. You should be looking to include standards for the installation, the support, the maintenance, even updates and upgrades. If you can, include milestones for implementation. Now, I would say that milestones on implementation are not necessarily relevant for every EHR contract. However, when dealing with hospital systems, it becomes critical to have certain milestones set that are definable and understandable. And I think that this next bullet point is one I would harp on. Sometimes with EHR systems, what happens is you're really trying to communicate between multiple groups of people that don't speak the same language. You have IT personnel, which, God help them, they speak a language of and unto themselves. It is quite challenging, in my view, to ensure that is what is being said at a high level technology, I guess, communication is translatable to both operations folks and to attorneys when drafting the contract. Frequently, attorneys will defer to language that has been drafted by the IT personnel and not really understand what's taking place. What I would challenge any of you to do whenever you're entering into an EHR contract, if you're getting language and terminology that is outside of your understanding, don't be afraid to ask questions and really make sure it makes sense to you. This goes back to the team approach, but you have to make sure that you have people that are communicating and you're ultimately incorporating service level standards that hit the mark and don't miss the mark. I think I'd also say on this one point, just the special issue of physicians. Regardless of where you are, whether you're a physician practice, whether you're a hospital system, or really almost any type of provider, physicians can be very reluctant to go along with changes to EHR systems. They are, as many of us are, tend to be animals who like to deal with things that they're used to dealing with, and change is hard, especially for physicians who are going to be focused on the provision of patient care. Fundamentally, if this impacts the ability to provide care, if it impacts their efficiency in ways that are negative, you're going to have mutinies on your hand, and that can be a headache. Getting them involved, making sure that you had appropriate representation, I'll say of physicians, but ultimately the end users and practitioners of the system is critical. Make sure to bring groups in and run this across the board so you don't get caught up down the road with say, even great service level standards that don't really match up with what the parties who are truly going to be using the system need. When we deal with service level standards, oftentimes we'll be including specific timelines. Are those timelines clear? Are they going to be definable? Are the consequences of failing to meet those timelines clear or those standards clear? And fundamentally, are they really what you want? This goes back to ensuring you're getting what you truly need, and that goes back to the team approach. I think that one other key issue on service level standards goes to conditioning payment upon satisfaction and demonstration that the technology is working as it was promised. I think that you want to get and make sure that you're withholding some form of payment and using that as leverage to ensure that the vendor actually provides you what you need. And that's a process. That's not something that is necessarily done the day that the vendor says implementation and transition has occurred. You, as the provider, need to be authorized to sign off on that final determination. It should not be left solely within the vendor's hands. When you're going at the service level standards, I think a big problem in many contracts is that you may have standards that obligate a vendor or an EHR system to perform at a certain level, and your only remedy is termination. And that is not often what either party wants. I mean, frankly, if you run through things and you have a recurrent error. Let's say that you address how urgent support items are to be handled and that they must be resolved within 24 hours. If you don't have specific consequences to specific items that concern you, you may be left with having to threaten to terminate the agreement. And if anyone has gone through an EHR transition process, if you've been through that, you know that may be the last thing you want to do. The reality is you're wanting this thing to perform better. You want to have a system that works. You don't want to have to be changing EHR platforms every couple of years because you didn't afford more limited remedies than termination, but remedies that would have effectively captured the financial consequences to you. So think about this whenever you're drafting the contract. Try not to leave yourself just one giant hammer, the hammer of termination as your potential exit. Think about potentially, if you have recurrent problems, maybe you have the ability to reduce the length of the contract if there are enough specified occurrences of wrongful behavior. Obviously, payment is a key issue. Look at payment deductions as being a viable alternative to termination. Look at possibly having the opportunity to look to third-party sources to provide services such as support and have that be reimbursed by the vendor. For example, if you have a contract in which the vendor is responsible for not just the system, but with equipment that goes along with it, possibly there can be a whole host of things that could be provided within the contract, but only one piece of that contract isn't functioning. Say the equipment is just not satisfactory, but you could obtain that elsewhere, then set this up so that you would have that right and that the failure would fall financially at the feet of the vendor. And you're not left with having to go through an entirely new transition to a new platform. Obviously, a key is specifying damages for lost revenue if you've had an interruption that has affected the business. Can you define that? That's hard to do, but if you can, and you can put a monetary value on the cost of an interruption, then do so. And that gives you the opportunity to continue working with a vendor without having to completely change systems. We talked about this earlier, but to the extent you can condition payment on performance, do so. Avoid paying the full purchase price up front, set milestones, and work on demonstrated satisfaction. You try to, as a provider, you try to have a say in who determines that and also have a say in how the disputes are settled. Along those lines, it's pretty important to have a good dispute resolution process within your EHR contracts, and that isn't always just saying, hey, we're going to go to arbitration or we're going to go to litigation. I think that oftentimes having key point people from each side, dedicated personnel, for example, from the vendor side of the equation to be there and available to resolve disputes is critical to avoiding nuclear meltdown within a relationship. When you go through the service level standards, a key area that I would focus in is the implementation process. This, to me, ends up being one of the areas where there's the most cost to the provider and the most frustration for both parties. Providers usually, and when I say providers in this context, again, we're talking about these hospitals, providers, whatever you are, the purchaser of the EHR platform, oftentimes they just have not adequately invested in the training and conversion process. You need to ensure and understand how training is going to impact workflow and your revenues. You need to, as much as possible, work with a vendor. Usually a vendor, if they have worked with practices or providers of your type or your size, should have data and should be able to provide you their experience on implementing a system. Work with them, understand that, and get them get commitments, if possible, from them to achieve similar standards in your practice. We talked on this earlier, and that's the issue of physicians, and this is in the implementation process. in particular. I'll tell a funny story. I mean, attorneys are not immune from this. You know, my own firm has gone through a couple of different software platforms. While we don't have quite the amount of information, I would say, as healthcare providers, we still have to maintain that information confidentially. And you think that that physicians are bad, attorneys may be even worse in terms of changing their habits and practices. And when we've gone through these transitions, and having been through multiple ones, the ones in which we have truly understand what we're getting and that the product was not more than what we wanted have proven to be the most successful. Having a skilled group of trainers that understands the users and can understand the unique traits of the users is very important. Nursing staff is going to be different than physician staff whenever you're dealing with these things. How are your administrators, your billers, your coders, however it may be? How does each of them almost has a different perspective and a different history of working with a system. You want to make sure that they're all represented if at all possible. I think that what can frequently happen in this process is that the implementation is so strong, providers get dissatisfied and they want to withhold payment regardless of the contract terms. You'll get providers who say, well, we don't really care what the contract says, we're not going to pay you unless this works. That's a bad situation to be in on both parties, from the vendor perspective and the provider perspective. Hopefully you can anticipate that implementation is going to be stressful and work to analyze that in advance so to mitigate the downstream issues. And along these same lines, resist the pressure to go backwards. Once you've made the commitment and you've moved to a new system, you'll hear some folks that want to go back or to build in new system dynamics or system add-ons that allow them to function as the old system did. In reality, the old system probably needed to be upgraded, and you're just going to have to bring everyone along. Keep in mind that the vendors can restrict the use of the system if the physicians or the other providers aren't complying with the standards. That's true, especially in my view of cloud-based systems. The vendor has the right to protect its system from abuse, and it's going to have some leverage over the practice along those lines. So having everyone on board on the implementation process is pretty important at the outset. So let's talk about some other specifics, and that's items, I'd say, for consideration whenever you're setting some standards. These are the specific terms that we'll frequently see these handled with an addendum or some sort of statement of work, schedule, however it's set up to an EHR contract. You know, what is the percentage of time that the system is going to be available for use? Look at, particular percentage, how's that going to be measured? Look at average execution time for transactions. And so what I mean by that is, let's say, what is the time frame for an application to launch? How many seconds? What about for logging into the system, starting an update, let's say to an office visit, signing an office visit? These things, in most cases, can be tracked by the vendor. You need to know, is the system that you acquired functioning at the level that your vendor committed to it functioning at? So as such, I often see on larger contracts where there are specific measurements that are put into play. Those things are in fact tracked, and there are financial consequences for failures to meet the standards that have been agreed upon. I think implementation deadlines for updates, if your vendor is to update your EHR, that's a critical bit of knowledge for you. You need to ensure that that update will be rolled into your system within a reasonable period of time, say 1 month. Are you going to have regular meetings with the vendor? Is there a designated contact? Specific interface issues can be addressed. How and what will occur? What will be the consequences for a failure for an interface to be achieved by a particular period of time? Similarly, I touch on system support. How will the vendor support issues that arise within the system? You frequently see this referred to as level 1, 2, and 3 issues, as well of what I would say problems that can arise on service levels, and I'll give an example. And this is what taken from a contract we worked on recently, a level 1 incident. That's one where the system is down. You've got data loss, the environment failure or safety is at issue, regulatory or system failure in the production environment. These are more significant issues, and you need to have terms that address how does a provider respond to an issue like this. Yours may be defined a little bit differently, but this gives you an idea of what that might be. Level 2 incident would be a critical component failure in a production environment. Level 3 would be an incident that requires resolution, but doesn't necessarily involve a critical system component failure or degradation of the system performance overall. So when you're defining your incidents, this is where the IT folks really need to be on board and understanding as well, in particular, understanding what does the vendor have from its side of the equation committed to supporting your practice. Is that going to be done by the vendor's own staff? Do they outsource that? Is that going to be handled by a group that is based outside the United States, in the United States? A lot of different questions that need to be asked, and some trial runs on how that would be handled are always good when the contract is large enough to warrant it. So I think we've touched enough on service level standards. I want to move into some other issues within the contract itself, and that's I think the third of those 5 key issues, and that's the issue of representations and warranties. When we're dealing with legal terminology, I think most people have an understanding generally of what that is, but run over it just on the basics. What is a warranty? A warranty legally is a promise that a proposition of fact is true. Basically, that someone is promising that what they've told you is in fact accurate. And certain warranties can be express, some can be implied. There's a difference on how those are legally treated in various contracts. Second thing is a representation. Representation is a statement of fact made to induce another party to enter into a contract. Many vendor contracts, many of these EHR contracts attempt to disclaim and delete all representations and warranties. What I mean by that is that when they have made verbal representations to you or even written representations to you or warranties along the way, that their contract will often say that those are disclaimed and effectively taken out of play in their entirety. In my view, this is inadequate. There are certain basic representations and warranties that an EHR vendor needs to make within its contract. It needs to represent and warrant that the product will perform in accordance with certain documented standards and for a reasonable period of time. There isn't necessarily a magic bullet to the language on what a representation and warranty should look like. It really can be very specific. However, here are some key items to consider whenever you're drafting or dealing with these issues. I would say that you want to ensure that the technology complies with applicable federal and state law. You're going to get into issues with HIPAA, currently with MACRA, kickback laws. There are a lot of laws that come into play in healthcare. I mean, we're dealing with one of the more highly regulated industries in America, and it's a large industry with a lot of rules. However, your vendor, as a vendor of EHR, needs to and should be familiar with these rules and represent and warrant that its system is compliant. I think that you also want to ensure that they're going to update their system to the extent there are changes in laws. That's been a big issue, in particular with when we were dealing with meaningful use issues, and I think we'll be dealing with it under future incentive payment models that come down the road, whether MACRA or otherwise. As you saw legal changes and you saw the pricing for healthcare services evolve from a regulatory standpoint, systems didn't necessarily evolve with them. And we had a number of practices that would have to go out and obtain a system that did deal with meaningful use because their old one hadn't been upgraded. I think it's very important, especially with as fluid as the world is nowadays, to understand that your vendor is knowledgeable of that and committed to being your partner not only now but in the future if changes arise. Other items to focus upon. Make sure that the vendor owns its technology and can stand behind that. Make sure that the vendor's employees are properly trained and credentialed to the extent that they are providing services to you. If you have software, make sure that the software doesn't include software, malware, viruses, worms, whatever else the new terminology may be. Seems like there's a new one every day. You know, I think ransomware is one of our big issues that we're dealing with right now, but having your vendor ensure that it's not providing you a product that will be a gateway to future malicious attacks is pretty important, especially with the consequences of breaches nowadays. Another thing that's specific within EHR, and think again, this is something that changes. This used to be a different type of certification, but right now, if you want to, and I've given you a link there where you can search different vendors to see whether or not the vendor is listed as active on the ONC Certified Health IT Product List. I think that's a good place to go to check out and see if your vendor is there. There's certifications that the government gives to different vendors to ensure effectively that the product is working at a level that the government thinks is appropriate. Good place to start. And if services are being involved, or services are involved in your contract on top of just the software platform itself, representations and warranties specific to the services are appropriate. You know, whether you're dealing with a very bland, commercially reasonable rep and warranty to something much more specific. I think on the issue of representations and warranties, we kind of then naturally evolve into disclaimers, disclaiming those representations and warranties. That's what a vendor will try to do frequently, and or limit its liability. They tend to be related concepts. So earlier we were talking about trying to get the vendor to commit to certain things within its contract. The vendor, to the extent you can get them to do so, will also be attempting to limit its liability, oftentimes appropriately so, oftentimes not. This is a big issue with EHR because I'm pulling some data that I had looked at a recent data breach study. You're looking at a cost per record on a healthcare breach is $402. You can imagine the costs that go into this. I mean, some of the most troubling issues we run into for providers right now, I mean, two of the biggest issues are employment law and HIPAA. Those are just hot areas, and HIPAA is expensive. If you have a breach, it can be bad. And the EHR contract often attempts to disclaim liabilities and or cap their liability to fees that have been received. Maybe they try to cap it to 1 month's fees, maybe a year's worth of fees. Some can try to get rid of all liability altogether. That is very problematic when you, as the practice, end up having the software malfunction, or you end up having your vendors, when providing services, inadvertently results in a breach. So from this standpoint, I think that you need to be looking to, as a provider, you need to be looking to the vendor to have them appropriately reimburse you for costs that fall at their feet. There are a number of different ways, and this can be sometimes the most challenging aspect of a negotiation, to come up with an appropriate solution. The larger the vendor, the more limited its remedies it's going to provide you. But it doesn't mean that the boilerplate language is truly where they say they're going to end up. Is it's a non-negotiable term is not usually the case. There are compromise solutions to consider. You can look to figure out what the vendor's insurance coverage is, if they're providing services, if there are other things that are there. Do they have cyber liability coverage, and what are those limits? Understanding that's critical. Understanding that even the most egregious limitation of liability clause is subject to applicable law that will trump it. Many states aren't going to uphold clauses or will not enforce them whenever you're dealing with fraud, gross negligence, willful misconduct, that type of thing. Fundamentally, try to avoid ambiguity and get those specific exclusions in your contract from the outset. Don't rely on the fact of, oh, well, I know state law may override this horrible provision. Don't go that route. If state law says that you can't limit liability for particular action, have the party commit to that and agree to it. And I'd say one special issue, and this is unique in some respects to EHR, frequently you'll enter into a business associate agreement at the outset of negotiations with an EHR vendor, and then you'll subsequently enter into the EHR contract. Oftentimes, even if you've negotiated a favorable provision in the EHR contract, the BAA, as we refer to it, may have its own limitations of liability within it that would serve to be in conflict with and or supersede what you've negotiated. Make sure you understand how your BAA and your EHR contract work together. If you fail to do so, that can be a major problem. So kind of talk on the final issues, and that's on transition of data. Again, I have it here upon termination, but that can be at the outset of the relationship as well, because you'd be terminating, even if you're moving from paper records to electronic records. There's some specific issues, and this is probably aside from implementation, which is a big operational headache, this is probably one of the areas that leads to the largest area for legal disputes. In reality, notwithstanding the fact that the goal is to have systems that communicate, I feel like I'm back in the 1980s and struggling oftentimes with Beta, Max versus VHS. We've got some systems that just don't communicate with each other and they don't function. And it becomes challenging to provide a clean electronic data in a conversion. And think about it from a provider standpoint. You, as the provider, are responsible for maintaining a full and accurate patient record. And if you're moving from one system to the other and your data does not move in a complete fashion, to what extent are you going to be liable for that down the road? I mean, have you committed malpractice just from the outset because you no longer have a full medical record? What happens if there's a dispute down the road? These are challenging and difficult issues, and the obligation and onus is ultimately on the provider to ensure that this data comes across appropriately, so it has to contractually obligate the vendor to do so. The costs are significant to transfer data. Frequently, you need almost a transition team to work through these issues. You have oftentimes competitive systems that don't like working with each other and are not necessarily inclined to do so if they've lost the contract. I don't know what the right format's going to be in 5 years. I don't think anybody knows. I've got some language I'll show on the next screen, but it's very challenging to know exactly what to put into an agreement down the road. Fundamentally, I think you have to anticipate the worst case scenario as well. What happens if the vendor's premises are destroyed? What happens if the vendor goes out of business? These things happen and can create issues where your data is in piecemeal fashion. It's incomplete, or as I have here, just a mess. I would note a special note on termination. It's often, and I think this used to happen more than it does now, but vendors sometimes, you would have this not necessarily always with just pure EHR vendors, but service vendors as well, wouldn't release data or provide access until payment. They may have an express provision to that effect within their contract. I've given you a link to a recent FAQ that was put out in which the government has stated the position that it would be a violation of HIPAA for a business associate to fail to release patient information or to provide access. That's something that you should definitely look at if you ever come across that issue and deal with the efforts of one party to block or terminate access to health information. I'm not going to go over this too long because I know we're running close to the end of the time, and we wanted to have a little bit of time for questions. But here's an example of two different types of provisions. One which is very vendor-friendly, which provides that the vendor has discretion on how to transition the data, versus a client-friendly provision with much more terms, much more specificity. The real world, though, is I don't know if this is going to work in 5 years. I don't know if an ASCII format is what we really are going to want then. This was specific for one client. It may not be appropriate for you. Don't rely on this when you're drafting your contracts, but it does give you an example of some of the key points to really be looking at whenever you're dealing with transition issues. One last item to think about are alternative tactics. because transition is such a big issue, how do you go about dealing with that downside risk where a vendor won't provide you access or won't provide the data, or the data is just not available because maybe they didn't do their backups and their server blew? Consider contractually requiring periodic downloads of data. Consider how often that would be if that's the case. We have seen in certain cases, you'll hear of source code escrow agreements. That's where you may be allowed and you place the source code of the EHR system into an escrow account. You wouldn't be able to access it unless there was some sort of termination or failure on the part of the vendor. Those are not for every occasion. I tend to see them as being more appropriate for very significant investments, because frankly, taking over the source code, even if you now have the right to use it directly to operate your system, is not an easy task. It requires you to have a fairly competent IT system to do so, an IT support network. So I think that tends to be more for big players who are dealing with things. One thing I don't have on here would be also making something to consider is ensuring that you may have access rights, user rights, just the ability to get into the system, maybe greater levels than you otherwise would, maybe if it's just a designated few number of folks to do so. So hopefully we've kind of come to the end of the review here. I think the one thing I always like to do before we get into questions, and this applies certainly to the questions, this is my own disclaimer, which is notwithstanding my earlier warnings, not to accept disclaimers. Since you guys are just in listen mode, you've got to take this one, which is keep in mind, and I'll say this, although jokingly, it is serious, these contracts require somebody who understands what they're doing and is familiar with your situation. When you're looking at these issues, if you're looking at language we've had or utilized in the presentation, for example, on service standards or transition standards, keep in mind that that's just for you to look at and consider. You should not be considering that legal advice when going into these issues. It's challenging, and you've got to have good counsel that can help you get through it. So I think that does it, Jill. I don't know if we have any questions or there's anything, if we have time to do that.
Yeah, Mark, great. We do have a couple questions. If you want to put up your next slide with your...
No question. You sure we don't want to just keep it on disclaimer
through
the
sure.
answer of the questions?
Sure,
because
sure.
God
Perfect.
knows that I probably need to disclaim the answers to the questions more so than earlier. Let's see.
Well, I guess along those lines of the disclaimer, when would you recommend getting your attorney involved in the vendor selection process?
Yeah, it's a fair question, and I think it's very fact specific. If you're a major player in the market, if you're a hospital, I suspect the attorneys are going to be involved, almost mandated to be involved at the outset. For people who don't have on-staff attorneys, it's a much more difficult question, and I think it depends a little bit on the size of the product that you're acquiring. What is it that you're doing? I'd say at a minimum, giving your attorney a heads up at the outset of, hey, this is coming, is good, because then you can have some of this back and forth to identify issues that are coming. But the reality is, whenever you really begin to get into that process of the contract and the language, you have to, I would say, involve them when that initial contract is coming into play, if not earlier. For example, it just depends on the familiarity that the practice has with BAAs. Those are things that, what I see the biggest issue is ensuring that the attorney has the full picture whenever they're assisting you. And if they don't, then you get piecemeal advice.
Next question is, you touched on issues arising when physicians resist the implementation of the EHR system. Are there any suggestions that you have on how to handle this problem?
Yeah, I think the biggest is involving them at the process at the outset. If you don't have the key players involved, then that's probably the biggest problem. And I'd say the other thing that people just overlook is they go, oh yeah, well, we got them involved in the process, but they didn't really listen. I mean, there's a difference between having them sit in committee and and hear about how Epic is going to help the world, and from the hospital standpoint, maybe that is the right system. You know, there are a million of them that are out there, but you know, does the physician truly understand what that means? I mean, have you gone through it and really tested it? And is it more than just the physician, you know, to get all the key people who are involved in the creation of a healthcare record?
Next question, what is the biggest problem that you see that providers face in the EHR selection process?
Understanding the system. I just think that's the problem, is you don't know what you're getting. You think you know what you're getting, but that communication process, the IT people may understand the technical aspects, and the physicians may understand medical process, but when you put it all together, they don't understand how the system works. It is either way too much or way too little, and there's just fundamental frustration.
Last question, do you think that the change into the Trump administration will have any material consequences on the future of EHR, and if so, what do you think they would be?
I don't know. I'd probably be good for lawyers, is my take. You know, all joking aside, when you look at some of the language, what I've seen out of the administration, the goal in some respects is to simplify the bureaucracy of federal government. Well, God knows that that the healthcare system is probably as bureaucratic as any that exists. So my hope would be that they truly invest in the issue of interoperability of the system to really have a meaningful record that works from the outset of the relationship and could be accessed from beginning to end. I'm not sure how that would be done, but that would be my hope, that that would align with some of the statements we've heard out of Washington. The other thing that I would say, the other key issue is data breach is going to, in my view, that continued focus is going to continually create issues and pressures on EHR vendors to ensure their data, their systems, and their platforms are consistent with government regulations. You add that with the financial consequences of in the meaningful use, the macro standards that are coming down the road. EHR vendors are going to be asked, and I think required, to ensure their systems are up to date. That's going to be a big challenge for some vendors, because these are times where we don't know, we have no idea what healthcare law is really going to look like next year, 2 years, 3 years. So big investments on the part of the vendors to stay abreast of it, and then that affects the providers. Are they going to be with a partner in 2 years that they can rely upon to adjust and change with the times? I just suspect that people are going to have to be changing systems more frequently than they would like to do so.
Well, thank you so much, Mark. And for the attendees, if you have questions regarding the content, please use his contact information there on the screen. Your Paycom CU certificate will be emailed automatically to you from Paycom. Please join us again tomorrow for another educational webinar, also at noon Eastern Time, Corporate Compliance for Federally Qualified Health Centers. You can register for this webinar and also request a demo of our compliance solution on our website at 1sthcc.com, or you can call us at 888-543-4778. Thank you very much and have a great day.